All right, welcome. If you're getting ready for the Queensland Bar, listen up because we're talking about one of the most powerful and honestly, one of the most dangerous tools in civil litigation, the search order. Today, we're going to break this whole thing down and turn that official practice direction into a practical guide you can actually use. Okay, so let's get right into it. You're going to hear the search order, which, by the way, used to be called an Anton Piller order, referred to as the nuclear option. And there's a good reason for that. It is an absolutely extreme measure. You only use it when there's a very real danger that critical evidence is about to just disappear. It literally allows you to go on someone's property to save it.
So just picture this for a second. Your client calls you, totally panicked. They are convinced the other side is about to start shredding documents, wiping hard drives, you name it. You know that the normal discovery process is just going to be too slow. By the time you get there, the evidence will be long gone. This isn't just some hypothetical from law school. This is the kind of real-world nightmare that these orders were made to stop.
So what is it, really? Well, officially, it's an order from the court that compels someone to let you search their premises. And its only job, its sole purpose, is to find and preserve very specific evidence that's at risk of being destroyed. It's an extraordinary power. Some people even call it draconian. And trust me, the court does not grant these things lightly. So you're thinking, okay, I need one. How do you get it? Well, you can't just ask nicely. You have to build an absolutely ironclad case. And when it comes to a search order, your entire argument, your whole shot really, it all comes down to one single document, your affidavit. Getting this right is, and I mean this, everything.
So here it is, your checklist. A judge is going to go through every single one of these points with a fine-tooth comb. First, you have to describe the items with serious precision. The court will never, ever grant an order for a vague fishing expedition. You need to know exactly what you're looking for. Then, you have to pinpoint the exact location. Now, here's the big one. You have to prove a real risk of destruction. This is usually the toughest hurdle. Just a bad feeling or a suspicion? That's not going to cut it. You also have to show the serious, irreparable harm your client's case will suffer if that evidence vanishes. And finally, some practicalities. You need to nominate an experienced, independent solicitor to supervise, and you have a duty to tell the court if any vulnerable people might be there, so the right protections can be put in place.
Okay, so let's say you do it. The court grants the order. You don't just get to show up with whoever you want. The court is meticulous about controlling who is on what's called the search party. Remember, this is not a raid, it's a very carefully controlled legal procedure.
So, who gets the invitation? The team is kept small and very specialized. The most important person there is the independent solicitor. Think of them as the court's eyes and ears on the ground, making sure everything is done by the book. You, as the applicant solicitor, will be there, of course. And if you're looking for, say, digital files or something super specific, you'll have independent experts there to help. And this brings us to a huge fundamental rule. Notice who is not on that list? Your client. That's right, the applicant is almost always forbidden from being part of the search. The reason is pretty simple. It's to avoid any hint of intimidation or confrontation. This whole thing is purely about preserving evidence, not about settling a personal score.
And the court doubles down on this idea by insisting that the search party be as small as it can possibly be. You have to remember, this is an incredibly intrusive event for the person being searched. So the goal is to have a minimal footprint. You get in, you secure the evidence, and you get out with the least amount of disruption possible.
And now we get to the day of the search itself. This is the main event. It's where all that careful planning gets put into action, and it's all governed by really strict rules of engagement that are designed to balance the power you've been given with the rights of the respondent. Even the timing is strictly regulated. The order is almost always served during normal business hours. Now, that's not just for convenience. It's actually a key procedural safeguard. It's designed to make sure the respondent has a real, practical chance to pick up the phone and get legal advice from their own lawyer right away. You see, the whole process is this constant legal balancing act. On one side, you and the search party have this incredible power to enter, search, and take away the items on your list. But on the other side, the respondent has rights that cannot be violated. They get time, usually up to 2 hours, to call their lawyer before the search even begins. And they can claim legal privilege over documents, which are then sealed up and sent to the court to sort out later.
The search itself might only take a few hours, but believe me, the process is far from over. What happens next is all about a series of very serious promises made to the court. We call them undertakings, and a follow-up hearing that decides what happens from here. These undertakings are the absolute bedrock of the whole system's integrity. Your client has to promise to pay for any damages if it turns out the order shouldn't have been granted. The independent solicitor promises to supervise fairly and file a report. But for you, as the applicant solicitor, the undertaking is profound. You promise to the court that you will not tell your own client what you found without the court's permission. At that moment, your primary duty is to the court, even above your own client. That's a huge ethical line you have to respect.
And all of this leads to what's called the return date. It's a follow-up hearing back in court, and it's basically the official debrief. The court goes over the independent solicitor's report and makes some really crucial decisions. What happens to the stuff that was seized? How do we protect the respondent's confidentiality? And importantly, this is where you'll formally ask to be released from your undertaking so you can finally talk about the evidence with your client.
So, there you have it. The search order is a truly formidable tool for justice. It lets you step in and act decisively when evidence is on the line. But using it requires so much more than just knowing the law. It demands impeccable ethics, absolute precision, and a deep, deep respect for the process. So as you prepare for your career at the bar, always remember this. You have the power, but do you understand the responsibility?